Right, welcome back. This is part 2 of the video lecture. And we're going to start here with opposing party statements. If you want a refresher, there's 2 other short videos. One is like 2.5 minutes just defining hearsay, and then the first half of this video lecture. So opposing party statements are statements that are attributed to either a named party in a civil lawsuit or the criminal defendant in a criminal case. And these are the party's own statements and the party's statement by adoption, that is, you agree that this represents you, then a statement made by someone who's authorized to speak, a statement made by an agent or an employee of the party, or a statement by a co-conspirator of a party. Adoptive opposing party statements are you adopt it usually in criminal cases. This means someone accuses you of a crime and you remain silent. So this is we will find the adoptive opposing party statement when we viewed from what would a reasonable person do if they were accused of kidnapping a child. Well, they would deny it, and therefore if you don't act the way a reasonable person would, you are adopting that statement. Vicarious opposing party statements they're not made by the criminal defendant, but they are made by somebody who's acting on their behalf. This is usually someone who's expressly authorized. For instance, if I tell a lawyer, somebody, that my husband is authorized to speak on my behalf and that what he says can be attributed to me, that would be a vicarious opposing party statement. Statements by employees or statements by co-conspirators. A co-conspirator statement needs to be made during the course of the conspiracy and in furtherance of the conspiracy. If the statement comes after the conspiracy has ended, this is generally after the arrest, then those statements are not going to be admissible. Now, shifting over from the first 3 things we talked about here into this, those were exemptions to hearsay. Now we're going to talk about the exceptions to hearsay. So some specific hearsay exceptions found in the Federal Rules of Evidence are statements made under sense of impending death, declarations against interest, spontaneous utterances, state of mind, former testimony, business or public record, pedigree or family history, past recorded recollection. So a dying declaration is the most restricted in terms of the foundation. There needs to be an initial showing that the defendant is unavailable. For instance, maybe they passed away. And in a homicide case, the statement needs to be made while the declarant, the person who's speaking, believes that death is going to be imminent and is made about its cause or circumstances. So if, for instance, to an EMT worker who responds to a phone call, and the person says to the EMT, "I think I was poisoned by my husband," that would be a dying declaration. So the declarant needs to be unavailable. It needs to be a prosecution for homicide for our purpose. The person needs to believe they're dying, and it must concern the cause or circumstances of their impending death. This is the belief that they're going to die is an essential element to admitting it. Now, the declarant does not have to die right away, but they need to believe, reasonably believe they're going to die. We're not going to jump ahead. The slides are pretty clear here to declarations against interest. This is another exception to the hearsay rule. This is made by someone who is not a party to the case and who is not available to testify as a witness. We need the person to be unavailable, and the statement needs to be against the financial or penal interests of the person when they make it, because this is thought. Excuse me. Why would you willingly say something that is going to financially harm you or potentially send you to jail or prison? And if you are saying those types of things, that they're very accurate, we don't have to worry about a lot of the other concerns with hearsay, that they're inaccurate or they're not representative of the speaker's intent. Again, here you need to be unavailable. Things that are against your interest are financial losses, prosecution for a crime are clear. Beyond that, when a suspect in a criminal case makes an incriminating statement that might also incriminate a third person, the prosecutor cannot usually use those statements as a declaration against penal interest. Okay. Now, the next exception is spontaneous utterances. These are just those kind of like knee-jerk reactions that you would say in response to something unusual or unexpected. These can come in under two different exceptions. One is a present sense impression. The other one is an excited utterance. Spontaneous reactions come in because you're responding immediately to the condition, and therefore you have a limited ability to lie or shape what you say in those circumstances. Now, we're going to throw this out there that social science research does undermine this. There is research demonstrating that people are less accurate in what they perceive when they're scared or surprised or excited. A present sense impression is Federal Rule 803.1, and this is a statement describing or explaining the event or condition immediately after you perceived it. This must be made to describe or explain an event or circumstance, and it needs to be made while perceiving or immediately after. So for instance, if you were at a downtown, you are waiting to cross the street, and you see somebody run a red light and hit another car, and you're like, oh my gosh, that person was going really fast. I can't believe they would race through a red light like that. That could be a present sense impression, as long as it is made quickly to your observation of somebody running a red light. Now, excited utterances are statements relating to a startling event or condition made while you were under the stress of the excitement. My car accident example could also apply here as well. Excited utterances can have a broader time frame depending on the circumstances. So for instance, if you observe that car race through a red light and cause a car accident, and you walked away, and then you came back and you were like, I just can't believe this. Why would somebody do that? Like what would cause someone to do that? They were going so fast. That could still maybe be admissible. While the present sense impression would need to occur during or right after the car running through the red light and causing the accident. All right. State of mind exception allows the declarant's assertion of their then existing state of mind. This is not to prove the truth of the matter asserted, but to prove that this particular state of mind existed at the time. There are three requirements. One, that the statement needs to relate to your state of mind at the time you made it, that the statement cannot be of a memory or a belief that used to exist, and that the circumstances indicate apparent sincerity, so that you were being truthful at the time you talked about your state of mind. Again, here the defendant would have, like, as of with all these exceptions, the declarant needs to be unavailable. These are considered state of mind or considered reliable because the declarant, is the best person to describe their own state of mind, and it's only limited to your state of mind, so there's less possibility for fabrication there. Inferring declarant and second party subsequent conduct. Now, on its face, there's not any specific limitations, but some state courts have done this. They have kind of went through and limited this. Now, our next exception are statements made for purposes of medical diagnosis or treatment. Statements that are made or pertinent to obtaining a medical diagnosis or a treatment that describe your medical history, past, present symptoms, sensations, when they started, and their general cause is an exception to hearsay under Federal Rule 8034. Now, these statements can be made by the patient or by somebody who's representing the patient with an interest in their well-being. So if a child takes their elderly parent to the doctor and says, you know, doctor, I've noticed my mom or dad doing these things, that would be acceptable. These statements can be made to anyone associated with providing medical services. So it doesn't actually have to be made to the physician. It can be made to a paramedic, the nurse, even a family member. So if an elderly parent makes those statements to their child because they feel like they need to go to the doctor, that might be sufficient. Statements of fault will not ordinarily qualify here. So if you say you were struck down by a car, that would count because that's important for your medical diagnosis. But if you say that the car was driven through a red light, that part would not, because that is not relevant to your medical diagnosis or care. All right. Next up is former testimony. So this deals with statements made at a prior proceeding is admissible in a later trial if the witness is now unavailable. And the testimony needs to be important. So former testimony used in a criminal trial, the defendant either needs to be a party of the former proceeding or have full opportunity to examine the witness. This exception is most often used in criminal cases when a witness testified at a preliminary hearing or a prior trial and is now unavailable in the first or subsequent trial. A deposition may count as long as both sides were given the opportunity to examine the witness. All right. And again, the witness needs to be unavailable. And these things count because the person was under oath. All right. These slides continue to go on for quite a while. I'm going to go ahead and stop the video lecture here. There's a lot of information here, and hearsay is an important concept to grasp. You're going to continue on to kind of make sure you review business and public records, as well as how a law enforcement intersects here, law enforcement reports and things. If you have any questions over these last couple concepts, please let me know. I'd be happy to talk to you more. All right, I will see you next week.